Seated. All right, good morning, everyone. I'm going to go through my decisions on the four pending motions. They're kind of grouped as two groups of two. I think the Dr. Vincent evidence is intertwined with the May 6, 2019 reverse Spriegel that the defense has proffered. And I'll go through the analysis and it'll hopefully become apparent why I see that they are intertwined. First of all, I'm going to deal with the May 6, 2019 incident because regardless of where and when we try this case, we have to decide this evidentiary issue. So, in analyzing whether anything from the May 6, 2019 case is admissible, I think we have to work in reverse chronological order here and deal with the issue of cause of death of George Floyd on May 25th of 2020. Because that is clearly a contested issue in this case. The medical examiner has opined that the cause of death was cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. The Armed Forces medical examiner concurs with that result. Medical examiner Dr. Baker also noted significant conditions of arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The defense expert, Dr. Fowler, has opined that the cause of death was cardiac arrhythmia due to arteriosclerotic and hypertensive cardiovascular disease during restraint by police. There seems to be a commonality that there is a cardiac incident here, cardiopulmonary arrest, cardiac arrhythmia, noting arteriosclerotic, but most importantly, hypertensive heart disease, and also the presence of possible drug toxicity. I would also note that one of the plaintiff's experts, Dr. Chauvin, cited a study which stated that clinical signs of fentanyl toxicity include severe respiratory depression. So the cause of death is clearly at issue here, the defense theory of the case being that it is due in part to drug toxicity and not to positional asphyxia or other causes. The state and its experts opine otherwise, saying that it is positional asphyxia and the restraint that was placed on George Floyd by the defendant. Clearly there's a cause of death issue here. In fact, it is highly contested. The fact that we have cardiac involvement and hypertensive heart disease leads me to question whether there is anything from the May 6, 2019 case that is relevant on the issue, the medical condition, or the mechanism of death, because that seems to be the primary issue. What is the mechanism that caused the cardiac arrest or cardiac arrhythmia, depending on which expert you talk to? Is there any medical evidence that would contribute or be probative as to cause of death? On May 25th, 2020, the date of Mr. Floyd's death, there is a very similar starting situation as on May 6, 2019. That is, an officer approaches him while he is seated in a car. He is at gunpoint. The police have a gun pointed at him. In the May 25th, 2020, was Officer Lane. They both holster their guns at some point, but there is a shocking interaction between the police and Mr. Floyd. Shocking to Mr. Floyd. That is fairly clear. There is also evidence of drug concealment upon being stopped by the police. basically concealment by ingestion. In other words, that he was eating and otherwise hiding drugs. On the May 25th, there is evidence of that from a white object of some sort being seen in a photograph from a videogram. There is a pill in the backseat of the squad that he was ultimately taken to and through, which has Mr. Floyd's DNA and saliva, both, in the back of Squad 320. Toxicology results showing fentanyl, which is, as we all know, a powerful opiate, and methamphetamine. The defense theory as part of the drug toxicity is what contributed to his death. So how is May 6th, 2019 relevant to that? Well, there are certain things that are not relevant. Mr. Floyd's emotional behavior is not relevant to cause of death once he is pulled out of the squad car. His statements, while they are very similar to what was said on May 25th, don't really establish anything other than perhaps his mental state. And as I think the state correctly notes in its memo from yesterday on page 3, Mr. Floyd's internal motivations on May 25th are immaterial. Whether he was genuinely anxious, claustrophobic, or suffering a panic attack, or whether he was malingering, is of no consequence. He was exhibiting certain behaviors which are evident on both videotapes, both May 6th, 2019 and May 25th, 2020. But they were the behaviors, regardless of their source, regardless of their motivation, whether they were due to anxiety or due to malingering, doesn't matter, because it is the behavior that the officers in both cases were required to deal with. The behavior is remarkably similar in reviewing the tapes. However, that does not make the emotional behavior of Mr. Floyd admissible. Accordingly, that part of May 6, 2019 is not admissible. Generally, what he is saying up until the time he talks to a paramedic is not admissible. Nor the fact that the officers said this was part of a narcotics investigation and they suspected Mr. Floyd of dealing drugs. Not relevant, not admissible. The only thing that is relevant, again, we have to keep in mind, for cause of death. Any other purpose for which this is offered is not relevant and is unduly prejudicial and outweighs the probative value. But as to the point of cause of death and medical condition, May 6th is relevant. There is a modus operandi to conceal drugs in part by ingesting them, but also doing so in a very stressful circumstance. That is, being pulled out of a car at gunpoint and handcuffed. And so, what is relevant in the May 6, 2019 case that goes to cause of death or medical condition is essentially the video of the body-worn camera would be admissible from the time that the one officer approaches Mr. Floyd on the passenger side of the vehicle, the subsequent behavior with regard to eating drugs or not, his delay in complying. Again, when we get into resisting or complying, I don't think that is of any consequence. It is delaying in compliance, allowing him to ingest drugs, but more importantly, that heightens the stress on everyone, but most importantly on Mr. Floyd. Being pulled out of a car at gunpoint, I am sure, caused him great stress and was a very shocking incident. The only reason we know that this is relevant to cause of death and is probative is that subsequent to taking drugs while being encountered by police, similar to May 25th of 2020, Mr. Floyd was checked out by a paramedic. Everything leading up to that conversation with the paramedic is not admissible beyond that initial video up until the time Mr. Floyd is out of the car. Even the videotape, the body-worn camera, which I think was actually just placed on a table, of the paramedic's conversation with Mr. Floyd is also not admissible because it does contain some of the emotional behavior which is not admissible. But the paramedic can testify as to that this person was called to the scene to examine Mr. Floyd, to treat Mr. Floyd, and in doing so, he made certain statements which would be admissible as statements made for the purpose of medical diagnosis, specifically how much drugs, what kind of drugs, and the timing of the drugs, when the drugs were taken. Those could be hearsay, but it does fall within the statements for purposes of medical diagnosis. The other statements of Mr. Floyd are not admissible. The examination then discovered, and I don't have the exact numbers, and I didn't have the, I apologize, I don't have the timestamps or the exact, because I reviewed this last week. But it's my understanding that the blood pressure that was found was 216 over 162, or something in that neighborhood. It was over 200 for the systolic and over 160 for the diastolic. And I hope I got those right. But in any case, that's more than just a history of hypertension. It is clear from other records that Mr. Floyd had a history of hypertension. But what this shows, this blood pressure, is that he is now in a hypertensive emergency, such that the paramedic said, you have to go to the hospital because you could have a heart attack or stroke. That statement by the paramedic is not admissible. The reason for that is, as the state said, notice to Mr. Floyd that is not relevant. There's no really reason why he has to be told that. On the other hand, the paramedic can explain her actions in recommending to Mr. Floyd to go to the hospital because I'm sure her training is a blood pressure that high means someone is in a hypertensive emergency, and hypertensive emergency with a blood pressure that high can cause cardiovascular, cardiopulmonary complications. So the paramedic can testify as to why she recommended to Mr. Floyd to go down to the hospital. That does not mean that her video statements to him are admissible. I think it makes more sense for her to explain why she took the action she did. The subsequent treatment at the hospital, and the defense noted that Mr. Floyd was violent or otherwise, none of that is admissible. So what we have here, what I'm going to allow, is a portion of the videotape of the one officer from the time he approaches the car until Mr. Floyd is out of the car and handcuffed. And I apologize, I don't have a timestamp, but it's very clear that there's a shot of the back of his shirt. He's wearing a black shirt. At that point, he's been handcuffed. That's all that would be admissible. The pills that are in the crack of the seat would also, there's a photograph of that would be admissible also as part of that scenario. And then the blood pressure and Mr. Floyd's statements regarding that were made for purpose of that medical diagnosis. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs. We don't know exactly how many, but there was an admission that he had done it at the time of the stop. That is medical evidence. So we don't have the benefit of on-the-scene medical vital signs on May 25th. So the May 6th, 2019 case is relevant only to that extent. Mr. Floyd's emotional behavior, calling out for his mother, all that is not admissible because the emotional behavior in his state of mind is not relevant. The May 6, 2019 evidence is only admissible for the limited purpose of showing what Mr. Floyd's as an example of Mr. Floyd's bodily reaction, his physical symptoms upon being confronted in almost the exact same situation. Now, how does this affect the decision on Dr. Vincent's testimony? Dr. Vincent's report and her testimony would be strictly psychiatric evidence going to the state of mind of George Floyd. As I've said, this is not admissible. It's not by either side. The behavior itself is manifest on the videotape. And I believe the state has one expert who would say, the behavior you see on the videotape is not consistent with a cardiac arrhythmia. Perfectly appropriate opinion based on what they see on the videotape. To go further and say, have a psychiatrist say, this is due to or just consistent with anxiety, hypertension, or not hypertension, anxiety, claustrophobia, panic attack, really is just opining on the state of mind of Mr. Floyd and the mechanism or why he's acting the way he is. If the defense were to attempt to say that he's simply malingering, that would be speculation, and I would not allow that either. Because Dr. Vincent's testimony would go to the state of mind and interpreting the emotional behavior and its cause, that is anxiety, panic attack, claustrophobia, or even PTSD, is not admissible. Having said that, if the state believes that there is something the defense has done to open the door, we can discuss off the record or at least outside the hearing of the jury if the defense has opened the door to Dr. Vincent's testimony. Keep in mind that would be in rebuttal. Keep in mind further that if I allow Dr. Vincent's testimony, then the entirety of the May 6th case would be in because the defense would have a right to confront her opinion by playing the entire videotape of Mr. Floyd's emotional reaction on May 6th. And I think this illustrates both the benefit of motions in limine and the disadvantage of motions in limine. Number one, the benefit is we can try and parse through a lot of these very detailed evidentiary issues before trial so that we are not taking long recesses to discuss and brief while the jury is waiting. And so this is absolutely appropriate that this was dealt with by motion in limine. The disadvantage is we cannot, to every extent, script out this trial. Trials happen in real time, and there is just the true nature of it that things change. So accordingly, let's go with that idea is that if the state feels that the door has been open, we'll have a conference about that and I'll decide. But keeping in mind that if it is open, it's probably open to all the evidence regarding Mr. Floyd's emotional behavior and its evaluation. So that is the court's ruling. We're going to try and get as much of this down into a written memorandum. Over the weekend, Mr. Schaefer and I will be putting in some time to firm this up. But that is the limits that the court will allow. I think this is consistent with the Ness case, which said that it can only be for a limited purpose, and the amount of evidence regarding that limited purpose has to be limited as well to try and keep out as much prejudicial matter as possible. Now, as to the motions for continuance and for change of venue. The purpose of a change of venue is to ensure that the defendant has a fair trial by an impartial jury. The same is true as the basis for the defense's latest motion to continue, with the hope that as time passes, people forget some of the pretrial publicity. Unfortunately, I think the pretrial publicity in this case will continue no matter how long we continue it. Perhaps some of it may, with time, be forgotten by people. And as far as change of venue, I do not think that that would give the defendant any kind of a fair trial beyond what we are doing here today. I don't think there's any place in the state of Minnesota that has not been subjected to extreme amounts of publicity on this case. Change of venue is an option in the rule. when there is extensive pretrial publicity that is prejudicial, and there was prejudicial pretrial publicity, including the latest actions by the city of Minneapolis in settling the case. I'm not questioning whether they could or should settle the case at this time, but the bottom line is when it's reported by the press, it can affect the jury, it can prejudice or taint our jury pool. I'll be very honest, when that was first brought up by the defense, I thought they were overstating. I thought this really won't have an effect. People know it's a different case, different situation. I was a little shocked when we called back all the 9 jurors who had been seated, and 2 said it did move them off of being fair and impartial. We had all accepted them as fair and impartial jurors. 2 of them basically said that they could not be fair and impartial any longer. I was surprised that it had such an effect. That's probably a judicial bias. As a judge, I'm used to, okay, that's not relevant, so I'm just going to put it aside. So it is easy for me as a judge to disregard the fact that the city settled, knowing that it's totally different factors. But I have to remember that that's not the point of view that jurors are coming from. And so 2 said that they could no longer be fair and impartial. They were stricken. That left us 7. It is important to note that the other 7 did not feel that it was going to change their ability to be fair and impartial. Ultimately, on a motion to continue to ameliorate prejudicial pretrial publicity and continuance or change of venue for those purposes, is to find a fair and impartial jury. We have had 8 full days of voir dire from March 9th through March 18th, and now we're going to continue, hopefully, to select 2 more jurors. We had an initial jury pool of 326 from the random draw on February 1st based on all the summons jurors who returned questionnaires. We have gone through 95 panel members as of March 18th. 57 have actually been questioned. 22 were excused for cause on the parties' joint motion based on the review of the questionnaires. 16 were excused from the panel by the jury office between February 1st and March 18th after having completed questionnaires due to postponements, ineligibility criteria, for example, no longer resident of Hennepin County, non-citizen, over the age of 70, health-related, etc., but prior to questioning. Of those 57 panel members whom we have actually questioned during the 8 days of voir dire, we have selected 12. Defense has exercised 12 peremptories. State has exercised 6. And the court excused 27 for cause after individual questioning. I think it's worthy to note that I did give both sides extra peremptories. And people may wonder, how does that help? If I'm not going to change venue and I'm not going to continue the trial. There are jurors who are very clearly incapable of being fair and impartial. Some will come right out and admit it. Those are the easy ones. The court can excuse those when they say, for whatever reason, I cannot be fair and impartial. The next set are those who the court makes a finding that based on the totality of the circumstances cannot be fair and impartial. As I've said a few times during voir dire, just saying the magic words, they can be fair and impartial, does not end the court's inquiry. The court has to consider the totality of circumstances and decide if it has been established that they cannot be fair and impartial. There's a third class of jurors who don't say enough to establish a challenge for cause. Yet there are concerns that they still might harbor certain biases, and maybe it's rarely that they are lying to the court or to the parties. It's usually that they just have not done sufficient introspection, to be honest, and see how their biases affect them. It is for that reason that a peremptory challenge can be made if the parties believe that a person cannot be fair and impartial, that they would be biased against their client, be it the state of Minnesota or the defendant. That's the purpose of peremptory challenges. More were given after the settlement announcement because that would add an added layer of potential prejudicial pretrial publicity. And so to get at that third group, which might have grown in size because of their exposure to the settlement, that's the purpose of giving both sides additional peremptory challenges. To focus on that third group, which although they heard about the settlement, said they could be fair and impartial, but we all, or some, the striking party, had concerns that they could in fact be fair and impartial. And that's an appropriate exercise of peremptory challenges. Obviously, challenges based on race or gender, and that being the reason for the strike, are improper, and we've dealt with those on the various challenges that have been brought. With that, we'll continue with jury selection. We will continue with jury selection in this case and in this county. Accordingly, we'll take a break till 9 o'clock when our first juror is here. So we'll stand in recess until that time. Thank you. right, this is juror 96. Come on up and have a seat right here next to me. And you are juror number 96, correct?
Correct.
All right. A couple things before I turn things over to the attorneys. And first of all, sorry we had to make you come back after yesterday. We try our best to calibrate how many we can get to in a day, but sometimes things are not perfect.
It's not a problem.
Okay. First of all, I'm going to swear you in because all your answers have to be under oath. So if you'd raise your right hand, do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Also, we have plexiglass in front of you, between us, plexiglass in front of the attorneys when they ask you questions. I'll continue to keep my mask on. My point being, if you want to remove your mask at any time, feel free to do so. Either because it's more comfortable or to speak more clearly if you think it's necessary. You can take it off at any time. You can also put it back on at any time or just leave it on. Your choice, basically.
Okay.
All right? But in either case, mask or no mask, I'd ask that you pull a little bit, and I think you're there, so that we can hear you nice and clearly. Well, first of all, thank you for filling out the questionnaire. Gave us a lot of good information to start with. And is everything true on that questionnaire?
It is.
Okay. Any changes or additions to that questionnaire?
No.
Okay. And the reason I ask that is because it's been a couple months, and sometimes people, when they reflect on their questionnaire, think, yeah, probably should have put this down, or something I put down was inaccurate, or maybe even an opinion I expressed has evolved. The bottom line being, feel free and comfortable giving a different answer than what's in the questionnaire.
Okay.
All right? You'll find it comes up mostly, the attorneys will ask you specific questions about your questionnaire, and usually what they will do is read it, the question, and your answer, not to be confrontational, but just to refresh your memory as to what you said.
Okay.
All right? Now, the questionnaire also advised you not to read any articles to avoid the media about this case, but we understand that given the large amount of publicity on this case, that inadvertently you might have been exposed to a headline or a news blurb since you filled out the questionnaire to today. Do you recall being exposed to anything specifically?
Yes.
Okay, and what in specific?
The settlement.
Okay, and what details do you remember about the settlement?
It was just one of those ticker things that go across the bottom of a screen on the TV.
The hardest thing to avoid.
Yes.
Okay. How do you think that's going to affect you as being a juror in, it's a different case, but how do you think it'll affect you as a juror in this case?
I don't think it will.
Okay. Do you understand that that's a separate case, civil case, different parties, different legal issues, different laws that apply?
I do.
All right. Yeah, on a more general, well, let me ask, any other things that you've heard of in the meantime?
I have not.
Okay. Can you put aside, because you did know something about this case, as everybody who's answered the questionnaire knows something, can you put aside everything you've heard outside this courtroom?
I can.
Okay. Because you have to decide it just on the evidence that you hear in court based on the law that I give you. Can you do that?
I can.
Okay. Put aside everything you've heard, but also any opinions you might hold coming into this case.
Yes.
And as you sit here right now, do you feel that you continue to be a fair and impartial juror?
I do.
All right. I'm just looking at part 1, number 10. We asked that specific question, and you said yes, so I just want to see if that had changed.
Yes.
All right. Do you think you're pretty much, despite being exposed to some something about the settlement, you continue to be as impartial as before.
I do.
All right. Did you recognize any witnesses on the list you were given?
I did not.
Okay. Now, we anticipate that the trial is going to be about 4 weeks long, starting on March 29th. And we're pretty confident in that date, so I'm sure not going to be changed. We're not going to move it up either. So, does that work for you as far as timing?
It does.
Yeah, and I think you mentioned something in your questionnaire. If you could tell us what concerns you might have about either the timing or just being on the trial in general.
It's just my father's having a hip surgery at that time.
Okay.
So we're just trying to coordinate between my siblings, family members, and maybe different care facilities, how to care for him after the fact.
Okay. Do you think that the rest of your family can cover for it? And
I do.
okay. You also indicated some nervousness about the verdict. I'm going to leave that to the attorneys to talk to you about.
Yes.
But is there anything else that you think we should know before I turn you over to the attorneys?
Yes, I'm requesting some privacy regarding a question on the questionnaire.
I think I marked one myself for that. Yes. And I think that's appropriate.
Okay.
So I will grant you that privacy.
Thank you.
Basically, when we go, we call it an in-camera examination, which is an unfortunate, because most people think that means you're on camera, but it's not. Just a Latin term for more of a private conversation.
Yes.
Your audio will be turned off, so it'll just be us in the courtroom who can hear your audio. The reporters have promised, that are present in the courtroom, have promised not to report out any of the substance of what you're talking about, as if they were not in the courtroom at the time you talked about it. Okay?
Okay, thank you.
All right, with that, I'm going to turn it over to Mr. Nelson. As to juror number 96, Mr. Nelson, you may inquire.
Good morning, ma'am.
Good morning.
Thank you for being here, and again, thank you for your patience yesterday.
Yeah.
I would like to ask you, start with some kind of general questions, get to know you a little bit better, and then I'll follow up with some specific questions about your responses on the questionnaire, if that's okay.
Okay.
All right? So, ma'am, let's assume you and I were to meet under much different circumstances, a party or some sort of social or networking event, whatever it may be, and you and I have our first conversation. What are a couple of things that I learn about you during that casual conversation?
I would let you know that I'm a animal lover, specifically dogs. I have a passion for homeless and affordable housing. I would like to get more involved in that area. In Minnesota, I feel like there's a great need for that.
Okay.
I like to take long walks through nature, kind of decompress and relax during that time.
Sure. Okay. Wonderful. You'd obviously heard about this case before filling out this questionnaire, right?
I have.
And when you received the jury summons and you learned that you were a potential juror in this case, what was your initial reaction?
Go big or go home. It's kind of overwhelming. I know it's a high-profile case,
Sure.
so a little concerning.
Sure. And I think you noted in your questionnaire that you had some concerns about the verdict and the kind of consequences of a verdict.
I did.
Do you still have those concerns?
A little bit.
Okay. Well, let me ask you, when you got down to the government center yesterday and you kind of saw the fortifications and things of that nature, did it make you feel any safer?
It feels safe.
Okay. And when you heard yesterday that we're doing whatever we can to kind of protect your anonymity, did that make you feel better?
It's very reassuring.
Okay. And ultimately, at some point, however, your name may be released publicly as a juror in this case, but that wouldn't happen until the court deems it safe to do so. How does that make you feel?
I'm okay with that.
Okay, good. Let me ask you, in terms of your your concerns, right? There's two possible outcomes, guilty or not guilty. Do you think that your safety would be in jeopardy if one verdict was rendered over the other?
I do not.
You do not?
I do not.
Okay. So your concerns are sort of broad regardless of the verdict.
Correct.
Okay. And your concerns would not sway you or influence you to vote one way versus the other?
They would not.
Okay, fair enough. In your personal or professional life, can you think of a time when you've been called upon to resolve a conflict between two people?
Professionally, yes.
I'm sorry?
Professionally, yes.
Okay. And when you're kind of involved in that situation, how do you approach that? What tools do you bring to the analysis to resolve conflict?
So regarding the profession that I'm in, I would go to one of our staff members, ask them what the situation was, go to our customer, listen to what they have to say, and then I would apply our company policies to resolve the situation.
Okay. Now, obviously, this case involves questions of conflict, and that those conflicts may emerge in various levels. There's the broader conflict, which is the state of Minnesota versus Derek Chauvin, and that's ultimately what you would be tasked with resolving. But in the jury room, you've got 12 jurors. You're one of 12 people who have to ultimately decide this case. And conflict may emerge amongst the jurors. Could you foresee that happening?
I could.
All right. And it may be in various forms, right? It may be over certain pieces of evidence. It may be interpersonal conflicts. People just don't get along. We don't know because we're not going to be there with you. But generally speaking, let's assume that in the jury room there's conflict between how to interpret evidence or various, a single piece of evidence or various pieces of evidence, and you have two groups, and you haven't made up your mind yet, right? And you are looking at these two groups and the conflict over how to interpret that evidence. How do you approach that situation in those circumstances?
I would allow the courtesy of both sides to reply, to give their opinions, maybe back up the facts how they see it. If it's getting out of control, I feel like I am good at de-escalation things, and just try to have both sides come together for a resolution.
Okay. Do you think it changes the analysis if you're involved in the conflict, meaning you've already made up your mind and you're on one side and there's a group on the other? How do you think it changes if you are a part of the conflict as opposed to observing the conflict?
I would like the opportunity to give my opinion and my side of things. I'm also willing to listen to their point of view and together come to a resolution.
Okay. And do you think that you're the type of person who's going to simply agree with another person just to get it over with or to build consensus?
I do not.
Okay. So you'd be willing to kind of stand your ground if you think something is important?
Correct.
Okay. Again, whether it be in your personal or professional life, have you encountered a situation where you've been asked or trying to figure out if someone is lying about something?
If somebody what?
Is lying about something?
Yes.
Okay. How do you kind of process that? How do you analyze and try to determine if someone is lying to you?
Maybe re-examine the situation, ask more questions, see if the answers are consistently the same or if they would change.
Okay. Do you think that two people can observe a situation, observe it differently, and both be telling the truth, even though their stories may be different?
I do. I feel like people have two different points of view on the same situation.
Right. What types of things may impact someone's perception of events?
What they feel happened there, what they saw, might not always be the full case of it.
Do you think that people's past experiences impact how they perceive events as they occur?
They may.
Okay. Do you think people's training or education or professional experience impact how they may perceive an event?
Sometimes I feel like it could.
Okay. Do you take that into consideration when determining someone's past experiences or their training to determine whether they're going to be more truthful about something?
Possibly.
Okay. Can you think of a situation in your life where you were 100% certain that something happened, or 100% certain of some fact, only later to be shown that you were wrong?
I have.
Okay. And how do you deal with that when you've been proven wrong, so to speak?
I like to take a step back, re-examine the situation, admit that I was at fault. I would go to that person and apologize.
Okay.
I have no problem admitting my faults.
Okay. Now, ultimately, your job, as you understand, is as a juror, is to hear the evidence that's presented in court. Can you base your decision exclusively on the evidence as it's presented in court?
I can.
Regardless of what you may have heard or believed about this situation before court?
Yes.
And ultimately, at the end of the case, the judge will give you the law, right? You're the judge of the facts, the judge is the judge of the law. The judge will tell you what law applies in this case. And you may read that law and you may go, I disagree. I think this law is wrong, whether it's from a moral standpoint or you just think the judge messed it up. Can you apply the law as the judge gives it to you, even if you think it's wrong or should be changed?
I can.
Great. So I want to follow up. Thank you very much for your responses, ma'am. I want to follow up with some questions that I have on your questionnaire. You were asked a series of questions, or there's a series of references to a video. And I want to make sure what video we're talking about, because several have been released publicly. There is one video that was a bystander took a video of the arrest of Mr. Floyd. That video sort of went viral and became news, right? And then there were body camera footage from the officers that were released, as well as some surveillance and security cameras from their neighborhood businesses. Which of the videos do you think you've seen?
I've seen the bystander video.
Okay. Now, and when you say in your questionnaire, I think you say you've seen it 2 or 3 times. There's what we would refer to as kind of a longer video, a full-length video, and then the media has taken clips from that video and put it on the news. Have you gone and watched the full-length video?
Just the short version on the news.
Okay. So your exposure to the video has been only what you've seen in the media in various length of clips?
Correct.
Okay. And you were then asked to kind of detail and document what you knew about the case, or what you believed to be about the information you had about the case, let's say that. And you wrote a paragraph, talking about Mr. Floyd using a counterfeit bill. The police were called. Police ultimately respond. And then you wrote, several bystanders expressed their concerns, asking officers to get off him, and when officers continued their restraints, they began videotaping the incident. And you wrote, this restraint ultimately was responsible for Mr. Floyd's demise. Is that something that you have information about? How have you concluded that the restraint is what was the cause of Mr. Floyd's death?
I guess I assumed it was the cause.
Okay.
It's not based on anything else other than the video.
Okay. So you watched the video and you made some assumptions about that restraint and the use of that restraint, and ultimately we know that Mr. Floyd is deceased, and so you just kind of 1 + 1 = 2 analysis, or was your opinion influenced by what you heard in the media?
No, it's just my opinion based on the video.
Okay. If you were to hear, ultimately, one of the things the state has to prove beyond a reasonable doubt is what was the cause of Mr. Floyd's death. And you're going to, in all likelihood, hear differing medical testimony about what the cause of death was. Can you set aside your assumptions or opinions that you had formed beforehand, apply the presumption of innocence, listen to the evidence, and make a decision based on the evidence as it's presented in court?
I can, because I feel like the video may not show the entirety of the situation of what happened. It's a snippet of what happened. I don't know what happened before, and I don't really know what happened after.
Okay, fair enough. Now, I know when you filled out this questionnaire, there were questions as it pertains to all four officers that were involved in this situation, and we're only here today for Mr. Chauvin's trial. So there's a little bit of a difference in your response. I wanted to ask you, you were asked to state your general impression of the defendants generally. You wrote other, or you checked the box other, and you wrote, I have different impressions for each individual defendant. I do not view them all the same. So can you just explain what you meant by that, only as it pertains to Mr. Chauvin? How would you view Mr. Chauvin in relation to the others?
I feel like he took a different role in the situation versus the other officers.
How do you mean?
More like the leader.
Okay. And do you assign him more blame as a result of that role?
I do not.
You do not?
I do not.
Okay. You just view that he was perhaps a superior or senior officer on the scene, and that's it?
Yes.
Okay. Versus other officers who may have been newer to the force, younger, less experienced?
Correct.
And that opinion of Mr. Chauvin, would you describe just your opinion of Mr. Chauvin, if you were to say very negative, somewhat negative, neutral, somewhat positive, or very positive, what would it be?
Since I don't know him, I would base it off the video that I saw, and I would say somewhat negative.
Okay, and that's fair. Again, everyone's entitled to their opinions, and we're just trying to see if you're the right juror for this case. So in that regard, if it's somewhat negative, again, can you set that opinion aside, apply the presumption of innocence, and decide the case based on the evidence in trial?
I could.
You were asked your general impression of Mr. Floyd, and you checked the neutral box, and you wrote, I do not judge people because I do not know their circumstances, background, or upbringing. Why do you think that background or upbringing